Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome again to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What Happened in 2022? What will happen in 2023? Looking back and looking forward with the sector committees. This is the second part of a two-part special year-end episode. Antitrust Law Section members belong to many different committees, including our sector committees, whose job it is to stay on top of cutting-edge developments in all areas of antitrust, competition, and consumer protection law. In this year-end special, we'll be hearing from 6 of the section's sector committees representing some of the most important industries in our economy. We'll be looking back at the most important developments in 2022 and asking them for their predictions of the important cases and trends in 2023. My co-hosts are Sergei Zaslavsky and Jaclyn Phillips. Jaclyn, who are we speaking with first?
I'm excited to get started today with Chris Wilson and Francesca Pisano. Chris and Francesca are vice chairs of the ABA's Transportation and Energy Industries Committee. So taking a look back at 2022, what issue involving transportation and energy was really the focus for those of us in the antitrust world?
Thanks, Jaclyn. Hey, everyone. I'm Chris Wilson. I'll speak to you about trends we saw in 2022. And the main trend for 2022 has just been much more aggressive and far-reaching antitrust enforcement and more broader and more onerous remedies for transactions that raise antitrust issues. And as some of our listeners know, the Biden administration issued an executive order on competition, which directed antitrust agencies and other parts of the executive branch to step up enforcement of the antitrust laws. Now, that executive order called out by name certain industries, including those covered by the Transportation and Energy Subcommittee. What we've seen in 2022 is that the agencies have taken that executive order to heart. And as such, we've seen much more and more wide-ranging enforcement of the antitrust laws. So for 2022, I'm going to speak briefly on remedies that were imposed by the FTC in a recent energy transaction. And in this investigation, which was a merger of 2 energy companies, which had overlapping operations in a relatively small part of the United States, the FTC sought divestitures of one side's assets in that region. And as many of our listeners know, divestitures are a common and a traditional way that the agencies address competition concerns. But what was more perhaps controversial or novel here was that the FTC imposed prior notice and prior approval requirements for future transactions in the same energy market. So prior notice commitments require merging parties to notify the antitrust agencies of any future transaction, regardless of size or whether it's eligible for HSR notification. Prior approval commitments require antitrust agencies to affirmatively approve any transaction, whether or not it actually presents any competition concerns, and regardless of whether the transaction meets HSR filing requirements. Now, the FTC justified imposition of these requirements in this particular transaction on the grounds that it would help them better monitor market concentration going forward. Now, prior notice and prior approval provisions like these can be extraordinarily costly and burdensome to parties bound by them in at least 3 aspects. Now, first, they inject risk and added legal expense into future transactions by raising the likelihood of agency scrutiny for transactions that might not otherwise raise antitrust concerns. Second, they can lengthen the amount of time necessary to secure regulatory clearances, as it is impossible to do what's often called a, quote, sign and close if one of the firms is subject to prior notice and prior approval obligations. And third, they just create greater regulatory uncertainty, which can limit a buyer's ability to offer strong antitrust commitments in future transactions. Now, we certainly don't expect antitrust enforcement to diminish in 2023, but for market participants in the transportation and energy industries, we can expect the FTC to continue to vigorously enforce the antitrust laws, both in terms of increased enforcement of traditional theories of harm and remedies, but also of more novel or lesser used theories and remedies, as we've seen with the energy transaction I've discussed today.
Thanks, Chris. Very interesting to hear that, I guess no industry is safe from increased enforcement, as we're seeing, and we've seen a lot of in 2022. So, Francesca, Chris kind of hinted at some of this, but if you could now take your antitrust crystal ball and shake it up, what trends or specific issues does the Transportation and Energy Committee predict that we'll be seeing a lot of in the next year?
Sure. Thanks, Jaclyn. Big picture, we expect there to be continued interest in both antitrust policy and antitrust enforcement in the transportation and energy spaces. So one thing that I'll be curious to watch is whether anything will come out of the recent chatter around the NOPEC bill. And that stands for the No Oil Producing and Exporting Cartels Act. Now, some version of this legislation has been around for almost 20 years. And what NOPEC would do was try to authorize DOJ to bring suits against oil cartel members and attempt to revoke sovereign immunity for the OPEC country members and national oil companies. What's interesting is from an antitrust perspective, it's not exactly clear what the practical impact of this would be. So it's not certain how a federal court could enforce a judgment, whether a default judgment or a judgment after trial, on a foreign nation. But the implications for U.S. companies that might be alleged to be colluding with the OPEC members will be interesting to watch and is unclear. Big picture, though, I think some of the most interesting developments in this space that we'll see will be around the intersection of antitrust and ESG. And in our industries in 2022, we really saw just a huge increase of attention paid to corporate ESG, so that's environmental, social, and governance goals, in addition to the traditional bottom line financial results. Now, we know that both DOJ and FTC have recently said there's no antitrust exemption or immunity for ESG activities. And we've also seen activity from state attorneys generals here. So we've seen in the last several months dueling groups of state AGs releasing different letters. The first group warned companies engaged in some ESG activities that they might be violating the law. And then a second letter from a different set of state AGs sought to reassure the companies that their ESG activities would not be antitrust violations. And it's interesting to me because some of the most impactful and ambitious initiatives in the ESG space necessarily involve sector or industry-wide action. And we all know that coordination and contact among competitors can, in some instances, raise antitrust risk. I think one of the most interesting enforcement actions in this area in terms of thinking about what the future might hold and what the next year might hold is actually a case from 2021 in the EU. The European Commission alleged that a group of car manufacturers colluded on emissions reducing technical developments. And from what was alleged, it appears that the car companies held technical collaborations around R&D focused on reducing emissions in car engines. But the allegations are that as part of this technical collaboration, the car manufacturers allegedly agreed to avoid competition on better cleaning mechanisms in car engines, despite some of the manufacturers having the ability to design and implement better technology. A couple notable points when I think forward to 2023. So first, this alleged agreement grew out of what appeared to be a legitimate technical collaboration for emission-reducing technology. And from this legitimate collaboration, it seems like things spilled over into an alleged illegal agreement. I think that's important because even if you have sort of the best intentions at heart, and even if you set up an organization and dot your I's, cross your T's, you still have to watch out for spillover. The second piece is that the alleged agreement didn't seem to implicate prices at all. Instead, it was an alleged collusion on feature or performance innovation. We all know that firms can compete on many different dynamics, not just price, but also, as we saw here, product quality or perhaps even sustainability claims. So I think this particular case is a really spot-on preview of what we might expect from antitrust policy and enforcement in 2023, an increased focus on enforcement while coupled with ongoing innovation and activity in both the oil, gas, and energy sectors.
Thanks so much, Francesca. That's super interesting and gives us a lot to think about going forward. So, Chris, Francesca, we really appreciate you giving our listeners this recap and this insight into what's to come. And I hope you both have a fantastic new year.
Sergei, would you like to introduce our next guests?
Of course, we are very fortunate to be able to welcome Debbie Salzberger and Andy Ewald to the program. Debbie and Andy are the co-chairs of the Insurance and Financial Services Committee. Andy, can you tell our listeners about a really important development from 2022 in the finance and insurance space?
Yeah, well, there were really a number of interesting cases this year, but the one that stands out for me involved a pretty dramatic trial in New York involving allegations of price fixing foreign exchange rates. That trial was the culmination of 9 years of litigation, and it ended with the jury finding that Credit Suisse did not participate in a conspiracy to fix prices in foreign exchange markets. The case began all the way back in November 2013 and followed on a DOJ investigation. In May 2015, DOJ announced that 4 banks had agreed to plead guilty to conspiring to manipulate foreign exchange markets, and those banks agreed to pay more than $2.5 billion in fines. Another bank later paid a $90 billion criminal fine. Obviously, those are very large amounts, and they included the 3 highest fines ever recovered by the Antitrust Division. And the DOJ press release hints at why that might have been. According to the DOJ, the traders used a chat room that they colorfully referred to as the cartel to manipulate exchange rates. And then the civil antitrust claims were brought by putative classes of US-based and foreign plaintiffs. The court initially dismissed the foreign plaintiffs' claims as barred by the FTAIA, and then it later narrowed the US-based plaintiffs' claims as well, but it ultimately allowed the case to proceed against 16 banks. Nearly 5 years after the case was filed, in August 2018, the court approved settlements under which 15 out of the 16 banks agreed to pay over $2.3 billion to the class. Credit Suisse was the last bank standing. All of the settlements with the other 15 banks had included provisions barring claims for contribution and indemnification, and so that meant that Credit Suisse was facing tremendous potential liability for this alleged conspiracy that impacted markets where global trading averaged more than $5 trillion per day. The stakes got even higher after the court certified a class that included everyone who made foreign exchange trades between 2007 and 2013. Credit Suisse moved for summary judgment, but the court denied that motion in February of this year, and that set up this extremely consequential trial with a major bank facing hugely significant financial exposure. The trial began in October 11th, 2022, and after 2 weeks of testimony and argument, the jury was asked to decide 2 main questions. First, did the plaintiffs prove the existence of a conspiracy to fix prices in the foreign exchange markets? And the jury answered that question, yes. And that part of the verdict probably wasn't too surprising because, remember, these other banks had pled guilty and paid out billions in criminal fines and civil settlements. But then the second question was really the key. Did the plaintiffs prove that Credit Suisse had knowingly participated in the conspiracy? And on that question, the jury unanimously found in Credit Suisse's favor. That's not quite the end of the story. Plaintiffs have filed a motion for a new trial, and that's been fully briefed, and we'll have to see how that motion's resolved. And I'd expect an appeal after that. But whatever happens next, that jury verdict was one of the most interesting developments in the insurance and financial services space in 2022, because class action antitrust trials are a pretty rare bird. And in this one, Credit Suisse was the only one of 16 banks to take things that far, and it prevailed with billions on the line.
It was a very interesting trial and a big win for the defense, at least in the initial trial. We'll see where it goes from here. Well, Debbie, let's turn to you now. Can you tell our listeners what you're looking ahead to in 2023 in the finance and insurance space?
Absolutely. Thanks, Sergei. I think we foresee 2 major trends for 2023. Very much in line with what we've heard from other committees' predictions, we foresee increased criminal cartel enforcement that could spread to financial institutions, as well as increased civil enforcement of the prohibition on interlocking directorships. Those are the 2 key predictions that we'll make. In respect of the first, we expect that criminal cartel enforcement is going to be on the rise in 2023. The DOJ has become more aggressive this year, with its primary target, unsurprisingly, being monopolization by digital platforms. But the agency's gaze will spread to other industries. This has already begun with the DOJ securing a guilty plea and a $27,000 fine from a paving and asphalt contractor in November, in the first criminal monopolization case in decades. And despite the small fine, the fact that criminal charges are now on the table shows that there is bite behind the DOJ's bark. Financial institutions and crypto players may find themselves in the agency's crosshairs in 2023. Given what we've learned in the context of the foreign exchange rigging case that Andy just mentioned, common interactions within the industry and across competitor firms may create risk of improper information sharing and collaboration. Newer players, particularly in the crypto space, are also less likely to have systems or training in place to prevent improper information sharing. And so although most communications are likely completely innocent, common industry interactions coupled with what might be characterized as general skepticism or negative attitudes towards large financial institutions may well put FIs and crypto companies in the DOJ's line of fire. And alongside these developments, picking up on what Andy just discussed in respect of the Credit Suisse case, we've seen a clear shift towards data-driven decisions in antitrust cases, which could impact the course of enforcement and prosecution. As Andy described, despite the jury being presented with evidence of chats between competitors with names like the cartel, prosecutors were unable to provide data to show a conspiracy in the actual prices, which ultimately led to a decision in Credit Suisse's favor. For me, this highlights that prosecutors may have difficulty securing a conviction solely on the back of circumstantial evidence. Statistical evidence that establishes a conspiracy may well be needed and is another enforcement prediction that we'll make for 2023. On the civil enforcement side, I think we're likely to see the DOJ continue its active pursuit of illegal interlocking directorates under Section 8 of the Clayton Act, which prohibits a person from simultaneously serving as an officer or on the board of directors of competing corporations, subject to limited exceptions. We saw in October the DOJ announcing that 7 directors had resigned from 5 different public company boards across a variety of industries in response to concerns raised by the Antitrust Division. The statement announcing these resignations, along with multiple statements by other DOJ officials, have made clear that the DOJ is prioritizing a broader review of potentially unlawful interlocking directorates. And this can be a challenge when firms find themselves offside Section 8, even where different representatives of the firm have directorships on the board of 2 competitors. We saw evidence of this in 2022, and we expect that this will continue in 2023. In light of the DOJ's commitment to active enforcement, we think that these developments will be important for the 2023 activities of prospective buyers, particularly private equity and other investment firms.
A lot of very interesting stuff there, Debbie. In particular, I think one thing you mentioned really resonated with me, the growing importance of expert analysis and testimony in conspiracy cases, be it in financial industry or elsewhere, something I've also been keeping an eye on. Thank you so much to Debbie and Andy for joining us on our program.
And now I'm pleased to introduce 2 representatives from the Media and Technology Committee, Melanie Hollis-Kirsch and Suzanne Monk. We'll start with Melanie. What, from your committee's perspective, is one of the most newsworthy developments of 2022?
Alicia, so much has happened in the antitrust world related to media and technology in 2022. And when you say the words media and technology today, most people probably turn immediately to streaming services and big tech. But there's so much more to media and technology. Technology is present in so many parts of our daily lives and in every company. And the case that stands out to me today in 2022 is what I view as a technology case in the healthcare industry, the United Healthcare and Change Health Group transaction. It focused on claims editing and electronic data interchanges. And over the years, technology innovations revolutionized claims processing. The DOJ, joined by New York and Minnesota, sued to block the United's proposed acquisition of Change. The court found for the defendants and concluded that the government had not met its burden of proving that the transaction is likely to substantially lessen competition in the relevant markets. The defendants closed the transaction, and DOJ has given its notice of appeal. In my view, there are 4 key points from the court's opinion that we should think about in future technology cases. 1, the importance of the word substantially in Section 7 cases. 2, the use of remedies to solve the government's concerns. 3, the use of private equity firms as buyers. And 4, the importance of witnesses and real-world evidence. And in the few minutes we have, I'm going to focus on the remedies and private equity firms as buyers points. On remedies, over the years, we've seen a shift in the types of remedies that DOJ and FTC are willing to accept. It's not a new concept that the agencies prefer structural remedies over behavioral remedies, but the recent administration also stated that it would prefer to block mergers outright rather than consider structural divestitures. And the United Change case tested this policy shift. The court ultimately endorsed the party settlement proposal over the DOJ's objection. And in the areas of emerging technology, crafting divestitures can be really tricky. The judge placed substantial weight on the defendant's proposed remedy, which included both structural and behavioral fixes. To eliminate the horizontal overlap, United agreed to divest Change's competing claims editing business to private equity firm TPG, and the court found that the divestiture would preserve competition in the market. United also implemented an internal firewall policy which addressed vertical concerns and prevented the sharing of customers' competitively sensitive information. The court found that the firewalls were industry standard, that for over a decade, United had maintained a corporate antitrust firewall policy, and there had been no instances of firewall breach. The court also found that Optum's contracts required it to protect customer data. So in technology cases, sometimes there's no structural fix that would work practically. The court's acceptance of behavioral remedies and firewalls and the amount of the time the court spent on this issue, in its opinion, might be a slight setback for the agencies in future technology cases. Another point is that the facts really matter in each case, and when assessing the remedy proposal, I think we'll continue to see the FTC and DOJ object to remedies and continue to push back. The second point on private equity buyers is that the court lays out a roadmap for assessing private equity buyers, and it concluded that private equity buyers, in this case TPG, can be adequate divestiture buyers. We've seen in 2022 a focus from the FTC and DOJ on issues around the incentives of private equity firms and on the adequacy of private equity firms as buyers. The court explained in great detail why TPG would be a sufficient buyer of the divested business. And based on the court's opinion, when addressing potential private equity buyers, parties should ask themselves a couple of questions. Whether the evidence shows that the private equity buyer has the necessary experience in the industry to compete, whether the private equity buyer has significant experience with carve-out investments, and whether those investments were successful, and whether the evidence shows that the private equity buyer intends to invest substantially in the business. I think that's really important for technology cases in the future, especially in emerging industries. And I think we'll continue to see active enforcement by the DOJ and FTC, especially in technology sectors. So I think we'll continue to see a focus on the sufficiency of remedies and on private equity firms as buyers.
Well, in looking forward to the future, that's a perfect segue to asking Suzanne, what predictions do you want to make for 2023?
Well, thank you so much for having us. We think this is a great program. And I think 2023 is going to be the year of the guideline. So when we look at what's happened recently, the FTC issued their Section 5 policy guidance. And when Melanie and I were preparing for this program, we were talking about the impact that will have on media and technology businesses and the media and technology sector, because we think it'll be a focus of the FTC to consider applying the Section 5 guidance to that area. And as many folks know, on November 10th, the FTC issued their guidance. The statement adopts an expansive view of FTC authority and sets forth a more lenient standard for challenging conduct as unlawful. Section 5 has been an interesting area for many years. There's been considerable disagreement about the meaning and scope of Section 5 and how Section 5 interacts with other statutes, such as Section 1 and Section 2 of the Sherman Act or Section 7 of the Clayton Act. In 2015, the FTC's guidance took a focused approach to Section 5 enforcement by relating the Section 5 authority to antitrust claims that are also available to the DOJ and private plaintiffs. That statement announced that unfair competition would be evaluated under the rule of reason. The The FTC's analysis would be guided by the promotion of consumer welfare, and the FTC would be less likely to challenge an act or practice as unfair under Section 5 if the Sherman Act or Clayton Act were sufficient to challenge the behavior. And looking forward to 2023 and the current Section 5 policy statement, we see, a fairly significant shift from that earlier 2015 guidance. Now, the FTC is looking at conduct that goes beyond competition on the merits. So this could include conduct that's coercive, collusive, abusive, or otherwise restrictive or exclusionary, and the conduct must tend to negatively affect competitive conditions. So this could be conduct that tends to foreclose or impair the opportunities of market participants, reduce competition between rivals, limit choice, or otherwise harm consumers. I think for our media and technology sector folks, it's interesting that these principles are going to be weighed on a sliding scale. So looking at how the principles will be applied to conduct in our sector is something that we're really thinking about for 2023. Also will be interesting to see how the statement is effectuated, because we see that there could be potential hurdles for the adoption of the statement. Some courts, as other folks have talked about on this podcast, are wary of non-traditional theories. And you may also see staffing or resource constraints at the agencies that will limit the breadth and type of matters that can be brought. I think the key takeaway for our media and technology folks is looking at how this will be brought in cases that also fall within Section 1 and Section 2. So are you going to see a Section 1 and a Section 2 theory and a standalone Section 5 theory under the guidance? Or will they be using this authority in more specific Section 5 standalone cases? So I think it's going to be an interesting year for 2023. It's going to be the year of the guidance. We have the Section 5 guidance. We're also awaiting, merger guidance from the agencies. So that's our prediction for next year.
Well, thanks very much, Suzanne. And thank you, Melanie, for some very interesting insight. That is all for part 2 of our year-end special. Thanks again to all of our guests for taking the time out to speak with us. Listeners, be sure to catch part 1 of this special for more perspectives from other sector committees. And on behalf of the whole Our Curious Amalgam team, our very best wishes to everyone for a peaceful and happy new year.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.